Resume the meeting. It is now my great pleasure to welcome before this committee various witnesses who are here in relation to consideration of Bill S-8. As individuals, we have Mr. Mario Bellissimo, a lawyer, a certified specialist with Bellissimo Law Group Professional Corporation. Online, we have Mr. Marcus Kolga, Senior Fellow at the Macdonald-Laurier Institute. We also have with us here from the Ukrainian Canadian Congress, Mr. Ihor Michalchyshin, the Chief Executive Officer, as well as Orest Zakidalski, the Senior Policy Advisor at the Ukrainian Canadian Congress. From the Canadian Bar Association, we have Ms. Lisa Middlemiss, the Chair of the Immigration Law Section. And from the Refugee Center, we have Mr. Abdullah Dawood, the Executive Director. So I will now open it up to opening remarks from the various witnesses. Each witness will be provided 5 minutes. When you're cutting it when you're very close, and I just want to indicate you should be wrapping up your comments, I will hold this up. And that applies not only to your opening remarks where you get 5 minutes, but also when the members are asking you questions. So that all having been explained, I will now go to Mr. Bellissimo, who is joining us virtually. Mr. Bellissimo, the floor is yours. You have 5 minutes.
Good morning. Thank you, Mr. Chair, members of the committee. Thank you for the invitation. In our brief submitted before the Senate last year, we made 5 recommendations, which we repeat here. We endorse the concerns highlighted by the CBA and the Refugee Center. So why our recommendation? Context is always important. The current law is potent. As the committee knows, the authority to render individuals inadmissible under the IRPA for international and human rights sanctions has been in place for over 20 years. Of the thousands of people currently on the sanctions list, we cannot identify anyone that would currently be inadmissible under Canadian immigration law. But what's the harm in adding more sanctions? The bad actors should have no access to Canada. We agree. Yet it is much more complicated. The IRPA's jurisdictional integrity, for one, is at stake. Why? Aligning all of Section 4, 1.1 of the CIMA with the IRPA introduces, just to list a few, economic sanctions, where recommendations to sanction result in automatic inadmissibility, and where investigations into sanctions could be grounds for detention without legal context and without relief from third-party adjudicators like the Immigration Division. That will now be repealed. In short, the new law, make no mistake, is too broad. It can impact citizens, permanent residents, and foreign nationals guilty of no wrongdoing. This is striking. Applicants, their spouses, and children would have little, if any, options left under the IRPA. Generational impact. So recommendation 1 is the requirement for legislative clarity. We've heard a lot about it. The word sanction remains undefined, but it's also been divorced from grounds of violating human or international rights. It's now a standalone, undefined ground for inadmissibility, which currently exists in the IRPA. Why? Is this not the harm we are targeting? Bad actors in violation of human rights or international rights. Section 35.1 must be connected to human or international rights violators. Key terms like sanction and entity must be defined in the IRPA. This is all very important because subject matter experts in the sanctions regime, like Dr. Andrea Sharon, and a prior Senate study, raised several acute issues, too many to recite here, but to mention a few about sanctions: the need for parliamentary oversight, better coherence and compliance, timely and independent redress avenues, accountability, transparency, and other practical challenges. For example, Canada continued to leave sanctions in place against foreign states like Liberia and Sierra Leone long after the United Nations lifted them, a legal purgatory under Bill S-8. This committee should address that regime, and I understand it's going to study, before the passage of Bill S-8. Put plainly, individuals' lives could be significantly altered by a law that potentially should not apply to them. Equally troubling, it may not exclude some of the bad actors because the law becomes immersed in legislative ambiguity and applicatory limitations, resulting in procedural and fairness concerns possibly rising to the level of constitutional issues. Recommendation 2, legislative clarity is also required for the Citizenship Act and the Emergencies Act. That has not been discussed thus far. Canadians should not be at risk of losing their Canadian citizenship on a precarious legal foundation. Same for recommendation 3. With respect to dependents, IRPA cannot lose its jurisdictional integrity by being restricted in providing relief where justified in the confines of its own act. Ironically, in the sanction regime, there's legislated exemptions, but really none remain for those involved in navigating the IRPA. Recommendation 4 underscores the need for overbreadth and excluding those with no personal wrongdoing or any transgressions or any connection to transgressions. Recommendation 5, we rely on David Mattis's brief before Senate. Granting of refugee status should result in immediate delisting. Access to refugee status should be uniform in and outside of Canada. We propose calling David Mattis and Dr. Sharon to testify. It is critical we maintain the jurisdictional independence of the IRPA and its harmonious intersection with other domestic international legislation for the objects of the acts and the clear intention of Parliament to be realized. To get there, Bill S-8 needs further study and amending. Thank you.
Thank you very much, Mr.